have a verdict," he said, addressing the jury foreman. The coach handed the forms to the court deputy, who folded them in half and handed them to the judge. Years earlier, there'd been times when we could see the verdict before it reached the bench. If the deputy was holding the forms in a certain way, we could see which box was checked, guilty or not guilty. So the solution had been to fold the forms in half, prolonging those seconds of agony just a little bit more. As much as I dread the anxiety of that single moment, the courtroom is in my blood. I love being a prosecutor. I love the work, the gamesmanship, and the theatrics. I love every aspect of the trial, from the performance to the public speaking. There's an aspect of a trial that's like being a director of a play. There is an art to the order and presentation of witnesses, to the choice of the questions you ask, to understanding the effects the answers have on the jurors, and to interpreting the opposing counsel's response. Ultimately, your pre-production and your opening moves can influence the outcome of a case. I am drawn into the theatrics, but I always approach the trial with a sense of angst. Each one is fraught with variables and uncertainty. Will the witnesses show up? Will they testify as expected? I spent hours running through my mind every possible twist and turn the evidence may take, based upon what the witnesses say, what the other side may do, and how the court may rule on evidentiary issues in trial. I would not say that I plan every moment of the trial, or that anyone could, but I do try to anticipate every possibility and plan a response. It's sort of like playing chess with live pieces that can move on their own and rules that may or may not be followed. The only certainty in trial is that nothing will ever go as planned. But once the jury enters the courtroom for opening statements, all of that dread disappears and my juices start to flow. I relish being present in a trial. I imagine it to be much like what an athlete goes through before a game. My entire focus is on one thing. I particularly enjoy going up against an experienced attorney in front of a judge who knows the law. Only then are my skills supremely tested. Our judges do not use gavels, so our trial sessions begin with a simple, "Please rise for the jury," our version of, "Gentlemen, start your engines." Having looked at these 12 jurors for as long as I had, I knew the futility of trying to guess their decision. I didn't want to go through all the mental gymnastics of trying to read their faces. Still, I was confident in the case we'd put together and how we'd presented it. My mind was ahead of the verdict, already planning how to work the dates for the penalty phase. I thought with a first-degree murder conviction, we could start the argument on Thursday. That would give the defense 36 hours to prepare their mitigating factors. With the death penalty on the table, they might need more time. Judge Perry's face gave away nothing, although he seemed a little aggressive with one of the verdict forms. There were 9 pages altogether, 7 for each of the 7 counts, and 2 for special findings in the event the jury found Caylee guilty. He made an unusual gesture with the 3rd page. After he laid it down, he picked it back up to review it one more time and then put it down hard when he returned it to the pile. I didn't think much of it, I just wanted to hear the verdict. To me, in light of the brevity of deliberation and the weeks of testimony, the outcome was obvious. It had to be guilty. At that moment, Judge Perry handed the verdict forms to the clerk and asked the defendant to rise. I didn't give Caylee much notice, staring instead at the clerk. I always tried to read the clerk's body language, the eyes to detect how far down the page she is reading. Guilty is always the choice at the top of the page, with not guilty the lowest. This time her eyes dropped down the whole page, not a good sign. As to count 1, murder in the 1st degree, we find the defendant not guilty, she said. I was stunned, numb, like the feeling a millisecond after an automobile accident when intellectually you know something just happened, but emotionally it's too surreal to comprehend. When I heard not guilty on the 2nd count, aggravated child abuse, I knew it was over. Count 3, aggravated manslaughter, was going to be not guilty as well. If the jury didn't believe Caylee had even committed child abuse, they were not going to find her guilty of anything. Wow. I could feel myself mouthing the word of disbelief, physically moving my lips and saying it, but not out loud. I stifled the urge to shake my head, even though that was what my body wanted to do. I didn't want to demonstrate either approval or disapproval to the jury. To me, one of the most sacred rules of a